Alrighty, friends, welcome back to another episode of Law Schoolers. It's been a while. I've taken a pretty good break. Summer's been pretty good. I'm just working away. But I figured it was about time for me to come back and actually discuss the law again. And last year was really crazy as far as getting these podcasts out. I'm actually really far behind of where I want to be as far as getting these podcasts out go. I want to be a lot further. I've finished up some of the courses. I finished up all the 1L courses. And my goal is to have a podcast out for each and every single piece of material that is related to bar. And I haven't done that. As far as the 2L year goes, the 2L year took a lot out of me. So I don't have material related to business associations, constitutional law, ethics, and secure transactions. I have some material, but it's not complete as far as the podcast goes. Most of the material is complete on the website. Full outlines, everything for all these things except constitutional law and ethics is lacking there. But if we're looking at other courses that is missing from the podcast, you've got conflict of laws, evidence, and that's it. Criminal Procedure 1 is complete. And then again, all the 1L related bar classes are complete. So it's time for me to get back to it. A long way of saying I want to work and I want to get this done. And I want to feel good about getting this done. So that's where we're at. In this episode, we're going to be jumping back to content that I learned in the fall of 2023. It is now July of 2024. And so I'm a little behind, and some of this material might not be as fresh, but it's really good for me to review this material as well because it's going to help me prepare for the bar exam. Something that I'm a little nervous about, but believe that this will be good practice for me to learn and prepare for the bar exam by reviewing the material. So I'm just going to go ahead and pick up with where I left off, and I'm going to start with secure transactions because that was the course where I had most material already created before I ended up jumping off and hopping into the deep end. So we are actually going to hop into the deep end now, and we're going to pick up with perfection. So secure transactions, what we talked about last time, we finished up our discussions about attachment, and we did so by discussing the scope of Article 9. Now we're going to be focusing on perfection, and there are 5 ways that this attachment of collateral to the loan is actually going to be perfected. So what is perfection? Well, perfection is really the relationship that creditors have with other creditors. And it's important to determine perfection because it's going to be basing a lot of priority down the line. So that's really what you have when you have a secured transaction, collateral that is secured within the transaction, is creditors want this to be perfected, meaning that they have some stake in that priority part of it. So what is perfection? Well, perfection is the process that the secured party is going to protect their priority in some collateral against others who might have that claim on that collateral. So, in other words, perfection is just letting other people know, hey, I have an interest or I have some ownership rights in this property. If you attach, I'm going to be the first one in line, so beware if you decide to attach as well. So how do you perfect? Well, there are 5 main ways of perfection. The first and primary method of perfecting is going to be by filing a financing statement. This is outlined in Article 9, Section 9 through 10, and throughout the 9/500s. The second way of perfecting is by taking possession of the collateral. It's outlined in 9/313. Another way, the third way, is by ensuring control of the collateral. That's outlined in 9/314. Another way of doing it is simply automatic attachment. Not very common, but it does happen. That'll be outlined in 9/309. And then there are some other laws that may apply that determine perfection rules. This is something that we will get into later in the course. But PIMSs are going to be kind of along these lines where you've got super priority or things like that based off of how things perfect. These are all intricate little details that we will talk about later, but that's section 9311. So, in this episode in particular, we're talking about perfection, but we're wanting to spend most of our time on perfection discussing the financing statement, because the financing statement is the primary method of perfection. So, for attachment, if you recall what is required for attachment requires 3 things. And now this is really testing my knowledge, because I need to remember what 3 things are required for attachment. Attachment requires let's see. Yes. Attachment requires a value to be given. This is typically in the form of consideration. The debtor must have rights in the collateral. And then the third thing is that you need to have an authenticated agreement. That's going to be the typical method as far as attachment goes. So once you have attached, the next step is going to be perfection. And the main method of doing that is the financing statement. So most creditors, when they want to establish some collateral in your material, step 1 that they're going to do is that they're going to have you file that authentication agreement. And then after they do that, after that's all signed, they are going to create a financing statement and record that with the state so that other creditors could look that up. So what are the essential parts of the financing statement? What makes a financing statement valid so that these creditors actually have that priority that they're looking for in perfection? Well, the first thing is that it needs to have the name of the debtor, it needs to have the name of the secured party, and it needs to have an indication, not a description, just an indication of what the collateral is. So what that really means is that the authentication agreement is going to be pretty specific about what the collateral is. The financing statement is going to be pretty broad about what the collateral is. And the reason for that is because if you add collateral later, it might still be fine underneath the financing statement, which means that later attachment might also come back to this earlier perfection and be able to answer those questions. Sorry, I just got an email. And the whole point of the financing statement, as mentioned before, as far as perfection goes, is to put the debtor on notice. So the essential elements of the financing statement is going to be discussed in 9502A. So let's talk about these 3 parts more fully: the name of the debtor, the name of the secured party, and then an indication of the collateral. Start with the debtor name. The name of the debtor is going to be the most important part of the financing statement, because financing statements are going to be indexed by the name of the debtor. So when the creditor is searching for potential security interest that other creditors may have, that potential creditor is going to search the name of the debtor to see if there is any collateral that the debtor already has by another creditor. So it's going to be essential that the debtor's name is correct. And if it's not correct, well, then there's going to be disastrous effects for the original creditor, because it's going to destroy pretty much the viability of this financing statement, which means you're no longer perfected and you don't have that first place in line that you're looking for. So the debtor's name, the rules for the debtor's name is going to be outlined in section 9503A. And then 9506 is going to discuss what happens if that error occurs. Pretty much, if an error occurs, you're just going to ask if it's seriously misleading. So for example, if the name is incorrect, it is going to be misleading. But if the searcher is going to search for the name and the incorrect name still appears, well, then it's not seriously misleading. If it is seriously misleading, the financing statement is off the table. It's ineffective. You can't use it anymore. But if it's only misleading, well, then the financing statement may still be fine. So our step 1 is that we need to determine whether what is the definition of a name. That's going to be in 9503, as I just mentioned. We'll talk about that in just a second. And if that name is an error, well, then we need to come down here to section 9506 to see if it's seriously misleading or if it's just misleading. So what is the definition for a name? Section 9503. There are 3 different types of debtors and different ways to describe them. So first type of debtor is a registered organizational debtor. These are organizations registered with the state. As for them to be considered correct, the spelling needs to be as is registered with the state. So then you have organizational debtors. These are the second types of debtors. These are organizations that are not filed with the state. In these situations, it needs to be searched. Is going to be the name of the owner. And then the third type of debtor are individuals. And so there are 2 different ways that you could define an individual and how these names are going to be spelled. States are free to choose which alternates to use, but most states are going to end up using the first alternate. So, what's the first alternate? They're going to look at the driver's license. And the driver's license spelling is how it needs to show up on the financing statement. If you don't have a driver's license, well, then the filer is going to use the individual name of the debtor or the surname and first personal name of the debtor to look for it. The second alternative is going to be what's known as the safe harbor rule. And the filer can either use the individual name, the driver's license, or the surname and first personal name of the debtor when they are making that financing statement. So, just to summarize, as far as the name goes, the debtor's name, an essential part of the financing statement, it needs to be correct, and we look at 9503 to determine if it is correct, and if there's an error, we're going to go to 9506 to determine whether or not that error is seriously misleading. How do we determine whether it's seriously misleading? We're just going to see a search, and if the incorrect name comes up along with all the other stuff, well, then it's not seriously misleading and the financing statement is still fine. Okay, let's talk about the secured party name. It's another essential term, but it's not as relevant because we're not searching for the secured parties. That doesn't make sense. Think of it. Creditor number 1 creates a financing statement. Creditor number 2 goes to the same debtor, and instead of asking that debtor, hey, do you have any other creditors, and then searching for those creditors, which the debtor might lie about, the potential creditor has no clue if there is other creditors, so it does not make sense to search by creditor. So the secured party name is important for the purpose of making notice of who the secured parties are, but they are not actually going to be the deciding factor. So secured party name, not too relevant, but it's going to be helpful to know who potential creditors may need to contact for details about a security interest that they might be getting into with the with the debtor. Okay, final thing that we need to talk about is the collateral description. So the description of the collateral, as I mentioned at the beginning of this podcast, is going to be much more broad than the security agreement, the authentication agreement at the very beginning. So, just as an example, a financing statement may describe the collateral as all assets, and that's going to be sufficient for the financing statement to put creditors on inquiry notice of what collateral might be covered underneath the security agreement, not just what is covered underneath the security agreement. So, collateral description, just put them on notice. Here's what might be covered. So, what does that mean for creditors who want to file a financing statement? It's just going to make more sense to say all assets on your financing statement because the broader it is, it ensures that you're going to have your collateral actually covered that is described in the security agreement. Because the whole point in the financing statement is just to put other creditors on notice, other potential creditors on notice. So that's the whole point of that part. And those are our 3 essential terms of the financing statement. So let's just summarize what we talked about in this episode. At the very beginning of this episode, I talked about my goal to get back into actually describing this material and how it's going to be helpful for me to prepare for the bar. With that said, I'm hopping back into secure transactions. At the time, secure transactions, I was about a quarter of the way done going through the podcast, so I'm just picking up from where I left off, and that is perfection here. So as far as perfection goes, there are 5 main ways for perfection to occur. The primary method of perfection to occur is by filing a financing statement. And financing statements have essential terms and non-essential terms. And in this episode, we focused on the essential terms of the financing statement, which is the name of the debtor, the name of the secured party, and an indication, not just a description, or rather an indication, not a description of the collateral. And we talked about those different parts as well. But that's this material. I'm excited to be hopping back into things. I hope you are too. The break was nice, but I need to get back into it. I'll talk to you all later. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.